Well, thank you. An honor and a privilege that you would spend your time with me today, and such a pleasure for me. I want to read a quote to you from a United States Supreme Court case, Unalienable v. Dye. A constitution is designated as a supreme enactment, a fundamental act of legislation by the people of the state. A constitution is legislation directly from the people acting in their sovereign capacity, while a statute is legislation from their representatives, subject to limitations prescribed by the superior authority. Let me read that one more time. A constitution is designated as a supreme enactment, a fundamental act of legislation by the people of a state. A constitution is legislation direct from the people acting in their sovereign capacity, while a statute is legislation from their representatives, subject to limitations prescribed by the superior authority. Now, we can all say that this sounds pretty much like common sense. The people create and ordain a constitution. And that creates this thing called government, and we send representatives to sit in this thing called the legislature and act on our behalf. The important part in Ellingham is where it says, statute is legislation from their representatives subject to limitations prescribed by the superior authority. Why do I bring that up? I do so because so many people in America today are under the misimpression that government representatives can go to this room called the legislature and they can do whatever they want. And I would suspect if you lined up 100 Americans, just average Americans off the street, and said, once the legislature is in session and the representatives are seated, are there any boundary markers for the legislation that they can create? Is there legislation, which in and of itself is illegal? And I would bet probably 80 or 90% out of 100 would say, no, there's nothing they can do that's illegal. They make a law, then it's legal. Nothing could be further from the truth. We talk about an unconstitutional statute. We are talking about a law that goes beyond what as the court says in Ellingham, what the supreme enactment permits. And the supreme enactment, in my view, and I think the view of anybody who's a real American, who really cares about liberty and freedom, is that a constitution, even if not expressly stated, embodies the principles of the Declaration of Independence, even if it's a state constitution. Because the Declaration of Independence was signed by representatives of all the colonies of the time that then subsequently became states. And it speaks of inalienable rights. At the federal level, of course, the justices, the judicial system is attempting to shorn the Constitution of any connection to unalienable rights. And I believe people believe that that should or can be done at the state level. I believe in America, land of the free, that every constitution, state and federal, must be considered, even if not expressly stated, to embody the concepts of unalienable rights, and that legislation need not just violate constitutional prescriptions, but if it violates any of our unalienable rights, it is unconstitutional. I'm Dave Champion, back right after these words.